Good afternoon, sir. Step right up to the microphone.
My only issue is I never had my day in court. I kept getting, the attorney that's went up against me, he's supposed to go after the company for negligence and wrongful termination. Instead, he took the lazy way out and came after somebody that was on disability and kept playing down. I mean, every time I went to speak in the courtroom, he just squashed whatever I had to say. And I always thought it was my right for a jury trial, and I put up $100 bond for the jury trial. And I never got noticed, and I missed it by a day. And they rescheduled it. But then when I went up for the court date to have it rescheduled, they wouldn't hear my case. They just basically walked it over me. I never had a chance. So my only issue is here is I'd like to get my day in court with a jury trial. And my interpretation of the law is always wrong, but I've always assumed that it was my right to have my case heard by jury. They just denied me every time I had it. They just walked all over me. I don't know if it was because...
Now, did you receive a jury trial date?
I never got the date for some reason. I missed it by a day or two, and
So you're saying you just didn't get that correspondence?
Exactly. And then I called up about it, and they rescheduled it. And I went to that hearing, and then when it came up to go to that court date, I appeared, and they just wouldn't hear my cases. Sent it back down to district court. I mean, to Leominster Court from Pittsburgh for jury selection. They never gave me a chance. Never had my case heard. And this attorney's, I mean, I really like to have this case heard because the attorney, to prove his case, I think he did some unorthodox things to try to prove his case. And he went as far as to commit, I don't know if it's allowed to say this in court or not, but he went to the point and committed perjury to prove his case. And he let a company that was negligent get away with it. And I can prove it. I just need, my day in court.
All right, Mr. Abbott. Does anyone have any questions? All right, thank you, sir.
All right, well, thank you.
SJC-10608, at the top, Tempo versus McMillan.
Thank you, and may it please the court. Chapter 175, Section 181 of the General Laws rewrote an existing statute back in 1934. It was Chapter 160 of the Acts of 1934. And that statute did 5 things.
Could I just ask you this first? There was when we took this case, there was a question put to you about whether you wanted to combine the merits of your argument with the direct appeal, correct?
Yes, Your Honor.
But you did not want to do that, and you don't want to do that.
No, Your Honor, because this is a purely legal question before the court today, dealing with a portion of the summary judgment motion that was before the Superior Court. Factual considerations aren't involved. There are 3 material facts in this case. The date of the policy.
Isn't this about the immunity issue?
Yes, Your Honor.
Couldn't you have done that on the direct appeal?
Immunity is lost on a direct appeal. We took this up.
It's already been tried.
Despite my best efforts, Your Honor, I timely perfected an interlocutory appeal after the record was assembled in the Superior Court. I moved for a stay in the Superior Court. I moved for reversal of that.
Okay.
Okay.
Fair enough. But then it was tried. There is a judgment. I mean, I'm lost as to why you didn't pursue this as part of the direct appeal. If you're right, I mean, it's not going to make any difference one way or the other, right?
There's several reasons. I'm sorry to interrupt, Your Honor. This was already briefed, first of all. This was briefed last fall when it was still in the appeals court before the SJC picked it up. So we'd actually be taking away from this argument, which had already been exhaustively briefed, using the full page limits in the briefs to take care of it if we were to combine it. It also risks a conflation between the factual arguments and the inflammatory factual allegations in the case and what are material to this particular issue that's before the court, which just deals with the timing of the complaint with respect to the policy's issuance date. And in order to keep those two universes of facts from being conflated, it was incumbent upon us to insist that this be dealt with separately.
Thank you.
Now, back to the statute. The 1934 statute accomplished 5 things. First was it continued existing prohibitions on fraud and the inducement of policies by agents and insurance companies. But then it added several things. It added an enhanced criminal penalty at the end of the first paragraph, which took from what had been punishable by a fine of $100 to now a fine of $1,000 plus 6 months in jail. It also had a saving clause. The second paragraph said that regardless of what happens in this particular statute, it shall have no effect on Section 170 of Chapter 175, which is another criminal penalty applicable to agents who engage in the conduct prohibited by the statute. And the third paragraph does the fourth and fifth things that were accomplished by the 1934 amendment. It limited the time period in which you can bring a claim in the context of life insurance, and life insurance only, for fraud in the inducement to 2 years from the date of the policy's issuance. And then it also said that your sole civil remedy for doing so is to pursue a claim for rescission and restitution from the company that issued the policy.
Could I interrupt you one more time?
Yes, Your Honor.
You say we can get to the merits, or we need to get to the merits, because although, if I understand this correctly, there wasn't, that ultimately it was determined that you hadn't properly brought a direct appeal from the motion to dismiss.
Yes, Your Honor.
By bringing the summary judgment, you've revived the issue?
Yes, Your Honor. And that is dealt with. The court, after it took the case up, gave an order to myself and Mr. Waters to address why this was justiciable in this context in light of Little's. And the Barron's case, which was cited in Little's and overruled a lot of the other cases that were cited in Little's, really covers this. It's a federal.
Is that the U.S. Supreme Court case?
Yes, Your Honor.
So you think there's a difference between true summary judgments and, oh, no, Barron's, okay, all right.
Barron's
but
was
but it was different, because that case, there was a timely appeal brought, correct? But the court didn't reach the second issue.
I don't recall the timing in particular of the first motion in Barron's. I do know that there was a second summary judgment that was after the denial of the motion to dismiss that had been based on a claim of immunity, and it was allowed. And I believe it was in Little's that this court paid particular attention to the second summary the summary judgment motion being a last-minute effort to obtain a delay of a trial. It was filed on the eve of trial. In this case, the motion to dismiss, the motion for summary judgment was briefed and heard the first time a full year and a half before trial began, but it got put to the side because this court had taken up the first appeal and Judge Van Gestel had stayed the matter pending resolution of the first appeal. So this isn't something that was a last-ditch stopgap, let's try to avoid the trial type of effort. It was an effort to get this issue framed and adjudicated at the appellate level for the first time and once and for all. And it's a dispositive threshold issue in this case that, despite its being so significant, it's been more than 6 years since the case was filed, and the issue still has not been addressed. And it is about immunity. Now, the restrictive reading of the company and the statute of repose arguably applying only to the company leads into one of the things that the statute also accomplishes, which is the exclusion of remedies. If you take that restrictive reading and you say that the Statute of repose only applies to actions against the company. If you read it in light of the common law context, legislative enactments, both contemporary and subsequent, you've got to read the statute as occupying the field with respect to claims arising from fraud and the inducement of a life insurance policy. And again, that's life insurance only, and that's an important point that I'd like to address. The common law context prior to 1934, there was a right to pursue claims against both the company and the agent. There was a Harwood case, I believe it is, that was decided by this court in 1928, and the legislature was presumed to be aware of that. Second, there are legion cases in that same time period in the late 1920s, early 1930s, in which this court had held that legislative enactments which provide a specific remedy occupies the field and takes away other generally available remedies and actions that might otherwise have been available. And that was all in the same contemporary period as the 1934 adoption of this statute. Finally, there were subsequent enactments, Your Honor, that confirm the interpretation that Mr. McMenamin urges. First, Your Honor, there are two companion statutes in Chapter 175, Section 110B and Section 132. Both, again, are applicable in the life insurance context only. One requires a policy to include language that prohibits contesting the issuance of the policy further than 2 years out from the date of issuance. The other provides for actions on a lapsed policy to be brought no later than 2 years from the date of the last missed payment. And that's significant. That 2-year period is significant in both respects because we're talking about a life insurance policy. It insures the life of the insured. And if you have open-ended accrual dates like you would if a normal statute of limitations and normal common law remedies, if they governed in this situation, odds are in many cases you'd have what we had here where the actual insured is no longer available to testify in discovery and deposition because he'll have passed away or she'll have passed away before the dispute materializes. So that 2-year window in both Section 181, 132, and 110B is a rational window to draw, a rational line to draw in the context of life insurance. Now, the cases that Mr. Waters cites in footnote 6 of his brief that say that there's a remedy against the agent for various common law torts, not a single one of those arises in the life insurance context. And as I've said, and as the legislature specifically said itself in the last paragraph of Section 181, it applies only in the context of life insurance. I'm not saying that the limitation of remedies applies in the context of property insurance or professional liability insurance. I'm not saying that the statute of repose applies in such contexts. I see that my time has run.
Well, at least you can finish your sentence if you'd like.
I'm not saying that the statute of repose applies in those other contexts as well. It's only in the context of life insurance where the legislature made a specific policy determination in the context where it is likely that the insured will not be around to give testimony that could be helpful, and in this case would have been helpful to the defendant's case. Thank you.
Good afternoon. My name is Charles Waters. I represent the plaintiffs' appellees in this case. And let me be very clear. Mr. McMenamin is asking this court to rule that General Laws Chapter 175, Section 181, from 1934 on, permanently bars plaintiffs from ever bringing a claim against life insurance agents or life insurance officers. Mr. McMenamin is asking this court also to conclude and rule that that same statute also forever bars any claim against a life insurance company except for a right of rescission for misrepresentation. And the only remedy that Mr. McMenamin is asking this court to rule, the only remedy a plaintiff would have is to get the premiums back. Now, we believe that that's not what the legislature meant to do, and we believe that other statutes CMRs, and case law from 1934 on all demonstrate that. Judge Gantz, let me take a step back. Mr. McMenamin appeals here to this court from Judge Gantz's decision on summary judgment. Judge Gantz interpreted the statute at issue de novo, and he concluded that this statute is nothing more, at least paragraph 3, is nothing more than a statutory right of rescission. And he looked at the language, he looked at the purpose of the statute, and he looked at the public policy. And if this court looks at all three, it will see and agree with Judge Gantz and affirm Judge Gantz's decision that this statute, in fact, is not what Mr. McMenamin asks for it to be, but instead that paragraph 3 simply provides a right of rescission. So looking at the language, my brother is correct in that this statute, paragraph 3 of this statute, was enacted in 1934. Paragraph 1 was already existed. Paragraph 3 was new. That's notable because paragraph 1 only deals, I should say, deals with all insurance agents, brokers, and companies. Paragraph 3, the one that the legislature added in 1934, deals only with life insurance companies and agents and their officers. And when you look at paragraph 3 and the language that the legislature decided to use, the paragraph 3 is comprised of one sentence. The first part of the sentence speaks about officers and agents of a life insurance company and the prohibited acts, which are the misrepresentations. It then goes on in the second part of paragraph 3, that sentence, and it talks about such company. And it talks about such company relating to the cause of action or the claim that the insured can bring. And the language of the third paragraph also says that the insured may recover. It does not say shall, it does not say limited to. It said that the insured may recover. And then it provides restitutional relief. It provides direction and a procedure for the insured who's the victim of misrepresentation from any agent or officer of a life insurance policy. It provides the procedure that that insured, if they decide that's the way he or she wants to go, that insured can obtain the premiums back. And the language of the statute specifically provides for the insured to give back any monies that the insured received and any pay back any indebtedness. That is classic. That is classic relief in a misrepresentation case. Same relief you get in common law, and it's putting the parties back in the same position they were in.
Do you have any issue yourself with why this case is here under?
I do, but that's a broad question. I have a lot of issues with why this case is here. But are you referring to specifically the Littles case?
Yes.
Our position, the plaintiff appellee's position on the Littles case, Your Honor, is that Mr. McMenamin is barred from being here. The Littles case clearly demonstrates that a party that does not timely appeal an interlocutory right cannot revive it simply by adding it at the last moment to a motion for summary judgment, which happened here. In fact, we were here, as the court may recall, a couple of years ago on, in fact, the 211 Section 3 petition. The court found that Mr. McMenamin had missed the interlocutory appeal period by almost a year. He did not file any request under the appellate rules or under 231-118 for almost a year. And this court decided on 211 Section 3 that he had not timely preserved his appellate rights on the interlocutory issue. As soon as that case was remanded back to the trial court, the first act that Mr. McMenamin did was asked the court if it could include that same issue on the summary judgment papers. Judge Gantz allowed it over the plaintiff's objection because, candidly, plaintiff's counsel knew that this was going to be an effort to try to stop the trial and get the case back up on appeal. And mind you, one of my clients, the beneficiary of the life insurance policy that's at issue here, is an elderly widow who seeks the proceeds of that death benefits of the policy that was promised to her late husband. So one of the thoughts was that Mr. McMenamin would continue to delay the case, delay the trial, and bring the case back up on appeal of the summary judgment denial. And that's essentially what happened. Fortunately, the trial court judge, Judge Hinkle, as well as the appeals court justices, and I believe even the single justice of this court, all denied the request to stay, and we tried the case. And by the way, since we briefed the issue, the trial court has entered a 93A decision against Mr. McMenamin, has trebled the damages, and also awarded attorney's fees, and entered final judgment a few weeks ago. So, Your Honor, to give you a more succinct answer, we believe that McMenamin doesn't have the right to be here. On the other hand, we're here. I represent an elderly widow, and we believe that it is in the best interest of my client to get a decision on the merits of the statute at this juncture, rather than wait for the entire appeal to come up.
But the entire appeal is going to have to come up anyway, right?
I believe it will, Your Honor. This
isn't
issue
the
will
only-
need to be decided.
This is not the only issue that needs to be decided, though.
It won't be. That's true. The purpose of the language in paragraph 3 of the statute that we believe provides simply a right of rescission is based on the contemporary common law in the Harwood case, which, as my brother pointed out, was a 1928 case. If the court looks at that case, we believe that it's an insight to what the legislature was thinking when it added in 1934 that last third paragraph of this statute. And specifically, the Harwood case was about a misrepresentation that the life insurance agent had made, and there was a question that the SJC had about the remedy for the plaintiff. And it was because the policy was not with the agent who made the misrepresentation. The policy was with the insurance company. And that decision analyzes the issue with a plaintiff who's the insured seeking a right of rescission relief against the policyholder. That would be more akin, at least as it was alleged in that case, to a mutual mistake. And the SJC said it's not a mutual mistake. In fact, it's misrepresentation, and that the plaintiff can go against for the right of rescission, can receive relief from both the agent and the life insurance company. 6 years later, the legislature wisely concluded it makes no sense to go against the life insurance agent because the life insurance agent doesn't control the life insurance policy, and the life insurance agent wasn't given the premiums. Instead, the legislature said, we'll make this easy. We'll simply provide in this one statute a quick and easy mechanism for relief for these types of plaintiffs to go against the insurance company, to get the right of rescission, and that squarely addresses the concern that was laid out in the Harwood decision. Unless there are any other questions, I see my time is up.
Thank you, counsel.
Thank you.
All right. Hear ye. All persons having anything further to do before the Honorable, the Justices of the Supreme Judicial Court, now sitting in Boston within and for the Commonwealth. At present, depart to your attendance at this place tomorrow morning at 9 o'clock, to which time and place of sitting in this court is now adjourned. God save the Commonwealth of